in terms of the procedures they're supposed to follow, in terms of neighborhood watch, etc. You recall Ms. Thornville about you don't follow people, call the police. Second-degree murder. State's got to prove 3 elements. The victim, unfortunately, is dead. The death was caused by the criminal act of this defendant, and that there was an unlawful killing of Trayvon Martin by the act imminently dangerous to another and demonstrating a depraved mind without regard for human life. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. I am not going to let this effing punk or these A's get away. He's a criminal. An act is imminently dangerous to another and demonstrating a depraved mind if it is an act, a series of acts that a person of ordinary judgment would know is reasonably certain to kill or do serious bodily harm. I am following this guy, I'm armed, and I'm going to make sure he doesn't get away before the police get here. It's done from ill will, hatred, spite, or an evil intent. Defense is going to claim, oh, he didn't have any, he was just a little upset. Why is he having to utter those things? Why is he having to lie about the whole thing? If he wasn't doing anything wrong in following this victim, why does he have to lie about it? Why won't he admit that he went to follow him? Why does he have to come up with this, I didn't know the street, I didn't know the address? Doesn't that kind of show his mental state? It's of such a nature that the act itself indicates an indifference to human life. And in order to convict of second-degree murder, it's not necessary for the state to prove the defendant had an intent. It's not first-degree murder. We're not saying that he intended to go and kill him. Read those for a moment there. They speak volumes of his choices. Isn't that the truth? Isn't that the truth? Victim really didn't get to choose anything, did he? Or anyone? State is, the instructions that the court will read to you will tell you in part that the state has charged this defendant with second-degree murder. If you return a verdict of guilty, it should be for the highest offense which has been proven, and there's a lesser included. And Hurricane Katrina wasn't just a thunder shower. In other words, your duty is, if you find him guilty beyond a reasonable doubt of the highest crime, then if not, then you go to a lesser crime. Manslaughter, you committed an intentional act which resulted in the death and used a deadly weapon, excusable or justifiable. You'll get those instructions too about no accident or misfortune, etc. And the court's going to read the whole instruction to you. I just was. In terms of how you decide, and we talked briefly about that, it's to the evidence introduced into it alone. Case must be decided only upon the evidence and the instructions. What the lawyers say is not evidence, and you are not even to consider it as such. You may not decide because you're biased or sympathy or angry at anyone or feel sorry for anyone. Why do we have such rules? What if? That's not a lack of evidence. Could always be more. That's not reasonable. You will not hear, because a lawyer or Hollywood screenwriter can imagine something more than could be done, you must find the evidence lacking. You know, we don't have a big animation of how it happened. Did anybody see it out there? The defendant told the police this is what happened. There were no eyewitnesses to the actual shooting. Doubt? And again, what's not reasonable? Self-defense. This is what the defendant applied to Virginia, hunt down fugitives, and you'll see the letters, emails, etc. Isn't that true? Again, the key point is that injuries really are not required if a person is legitimately in fear for their life. But why exaggerate them? Unless he's lying about the whole thing. Yeah, no DNA. Fingerprints also weren't on the gun. Blood wasn't there. Credibility. But should you believe the defendant? Think about this. What a coincidence. Does that make sense? Think of the jacket as he's claiming he's going down an angle. Which way would it go? Would the gun be exposed? Or just the opposite? Think about this. Doesn't that speak the truth? What a coincidence. The shot, all of a sudden the yelling stops. You see where some of those injuries are? What, they pick up a sidewalk, or did he turn them upside down? Or is it just by scraping and rolling and fighting out there? They both were. I'm wrapping this up, believe it or not, and I thank you for your time and your patience. I ask you to come back with a verdict that speaks the truth, a verdict that is just. You heard from many people in this case, and I've summarized some of them. There's a lot more actually that you heard. We know you paid close attention throughout all these proceedings. Some of the people you heard from were the parents of both the victim and the defendant. Unfortunately, the only photographs left of Trayvon Martin are those ME photographs. I mean, they've still got other photographs, and you saw some of them, the football when he was younger days, but they can't take any more photos. And that's true because of the actions of one person. The man before you, the defendant, George Zimmerman. The man who is guilty of second-degree murder. Thank you.
Thank you. Ladies and gentlemen, we're going to recess for the evening. Before I let you go, and while you're getting your notepads to be ready to put face down, I'm going to give you my instructions. You're not to discuss the case amongst yourselves or with anybody else. You're not to read or listen to any emails, text messages, or social networking pages about the case. You're not to create or read any of those. You're not to get on the internet to do any independent research about the case, people, places, things, or events, and you're not to read or listen to any newspaper, radio, or television reports. Do I have your assurances that you will abide by these instructions? Okay, we will be in recess until 9 a.m. Please put your notepads face down and follow Deputy Jarvis back into the jury room. Actually, it'll be 8:30. 8:30. Please be seated. Counsel, you've got the final draft of the jury instructions and the verdict form. If you'll let me know in the morning if there's any issues with them.
I might point out just, Mr. Zimmerman's name is misspelled on the verdict form.
On the verdict form?
Yes. His name is spelled on the verdict form Z-L-M-M-E-R-M-A-N.
The one I have, it has Z-I-M-M.
It's actually because the I is capitalized, it's not spelled.
Right, it's the same as it is on the jury instructions.
Well, mine isn't. I thought I had the right one.
It's not it's the first sentence, not the
Not the
style. of
style.
Oh,
case.
I see. I thought you said the style. Yes,
No,
if
no.
you'll correct that on the first sentence.
Yeah.
It's
First,
throughout.
second, and third, all of them.
Yeah, all of them.
You put a capital I instead of a small I in all those.
I guess.
So the second page seems to be fine. It's the first page. And if you'll let me know if there are any other concerns or issues regarding the jury instructions. Is there anything else that we need to take up before we recess for the evening?
You're going to bring those other items in the morning. Thank you.
Okay. The other
Nothing?
evidence?
Anything from the state?
No, I apologize, no, no.
That's okay. Thank you. Good night. Court is in recess until 8:30.